Good evening, everyone. I'm Lincoln Davies, and I have the honor of serving as the 20th Dean of the Moritz College of Law here at Ohio State. I'm joined today by my co-chairs on the Education for Citizenship Initiative, Keisha Mitchell, the Associate Vice President for the Office of Institutional Equity, and Dr. James Moore III, Ohio State's Vice Provost for Diversity and Inclusion and Chief Diversity Officer. Together, we welcome you to what promises to be a vibrant panel discussion on the First Amendment. This is Constitution Week, when we commemorate the signing of the U.S. Constitution on September 17th, 1787. So this is a particularly opportune time for these kinds of discussions. At Ohio State, we celebrate freedom of expression and diverse ideas, and the Education for Citizenship Initiative is designed to nurture these priorities. With events like this one, we are seeking to inspire productive discussions on difficult topics facing our nation. Education for citizenship is our university's motto, but it is more than that. It's the spirit that guides generations of Buckeyes who have graduated from Ohio State, ready to be active citizens in communities across our state, nation, and world. To our students, faculty, and staff, we're so pleased you are with us tonight as part of this never-ending mission. For our panel this evening, we have three esteemed legal scholars who will help us explore a key First Amendment issue: where to draw the line between protected speech and defamation. The panelists are Ronnell Anderson-Jones, a former newspaper reporter and editor, and affiliated fellow at Yale Law School's Information Society Project, and the Teitelbaum Chair and Professor of Law at the University of Utah S.J. Quinney College of Law. Also, Leonard M. Baines, the Dean and Professor of Law at the University of Houston Law Center, and finally, David A. Logan, Professor of Law and former Dean of the Roger Williams School of Law in Bristol, Rhode Island. Please see the Education for Citizenship website, which is listed on the screen now, for more information about each of our impressive speakers this evening. They will be discussing the landmark Supreme Court case of New York Times versus Sullivan, which helped to establish the standard of proof for public officials who sue for defamation. This ruling is from 1964, 57 years ago. In recent years, given the changes precipitated by the internet and social media, some say, including Supreme Court justices, that it should be re-examined. The question of whether New York Times versus Sullivan should be re-examined is at the center of tonight's discussion. To assist with the panel, three students from the Moritz College of Law here at Ohio State will help moderate our discussion. They are Joey Otang, Carly Sinclair, and Paul Stahman. To the audience, any comments that you submitted ahead of time were provided to the moderators as they formulated their questions. Now, Joey, will you please help lead the discussion with our panelists?
Awesome, wonderful. Thank you all for making time for us today and for the university, faculty, and staff who put this panel together. Thank you for making conversations and ideas accessible to our community and beyond. To begin, I wanted to offer some larger questions that I hope our esteemed panelists and moderators will thoughtfully approach in ways that meet the needs of our dynamic audience. Those questions are: what are truth or facts? How do we know? Who gets to determine those things? How has the landscape of free speech and the freedom of the press changed with the shift of widespread social media? What role does the legal system and the legal academy have both in adjudicating over First Amendment issues and educating the public about protected speech, media literacy, etc.? Our panelists have prepared some opening remarks. Professor Anderson-Jones, will you start us off?
Thanks, Joey, and hi, everyone. It's wonderful to be with you tonight for what I'm sure will be a vibrant and engaging conversation. Thanks to Dean Davies, Vice President Mitchell, Dr. Moore, Molly, Rob, and Jason for their organizing efforts, and especially to our student moderators. The conversation topic tonight, as Dean Davies said, was spurred in large part by a statement earlier this year from two justices of the US Supreme Court that the watershed First Amendment precedent set forth in New York Times versus Sullivan ought to be reconsidered in light of the new social media landscape. I've been tasked with giving you all the story of the Sullivan Doctrine, and then we'll offer some very brief thoughts on why, despite completely agreeing that the social media disinformation landscape presents some grave risks deserving of our immediate attention, I think unwinding Sullivan is unnecessary and potentially counterproductive as a blow to both American-style freedom of speech and our goal of getting accurate information to the people in our democracy. Sullivan, decided in 1964, was a major First Amendment decision from the Supreme Court. Before it, every state set its own rules for how a person who thought that they had been libeled could sue. And most simply used the old common law approach, which said that a person suing for libel could win if they simply showed that they were identified and that something defamatory was published about them. Importantly, they didn't ordinarily have to prove that the thing that was said about them was false, and didn't have to show that the newspaper published with any level of fault, that is, knowing of that falsity or with reckless disregard for that falsity, or even with negligence or sloppiness. Instead, the libel plaintiff could win the case just by showing that something had been published that would harm their reputation and was about them. And the court in Sullivan recognized that this framework, especially in cases involving important matters of public concern, created a major First Amendment issue. The case arose out of an ad placed by an ad hoc coalition of civil rights leaders that were leveling charges against public officials in the Deep South in the midst of the civil rights movement, who had used violence and illegal tactics to quell the peaceful civil rights struggle. The basic thrust of the charges contained in the ad were important and were true, but the ad was filled with these small factual errors. Said the cops had ringed the campus when they had just lined up in front of it, said they had sung "My Country 'Tis of Thee" as protesters, and really it was the national anthem. And so technically there was falsehood contained within the ad. Sullivan was a police commissioner of Montgomery, Alabama, and he sued and sought $500,000 in damages under Alabama law. And even though he was never named in the ad, and even though the factual errors were truly minor, and even though there was no showing that the Times knew or even ought to have known that the ad prepared by others contained these minor falsehoods, the paper was nevertheless subjected to this quite staggering $500,000 libel judgment, which was upheld by the Alabama Supreme Court. It was done in a clear effort to wield defamation law as a hammer to sort of shut them up, and it worked. The Times pulled coverage for a full year in response to the litigation threat. The United States Supreme Court, in its unanimous holding, said this dynamic is inconsistent with the First Amendment. It unanimously concluded that First Amendment protections for speech and press place limitations on state rules for tort liability in defamation actions. And so it said, going forward, in cases like this, you, the person who are suing for libel, would be responsible for proving up its falsity, and we would be responsible for showing something that the court termed actual malice. And that is that the newspaper, in this instance, had knowing falsity, engaged with knowledge of the lie, or with reckless disregard for its falsity or truth. Now, Justice Brennan, writing for the unanimous court, says we have to consider our system of libel liability against, quote, a background of profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. But this idea, this criticism of powerful public people, he says, is actually at the core of the First Amendment's purpose and its value to us as a citizenry. So the fact that some of these statements were false isn't sufficient to deny them speech protection, because false statement is, in Brennan's words, inevitable in a free debate. It's definitely going to happen that some falsehoods are published, but it must be protected if the freedoms of expression are to have what he calls the breathing space that they need to survive. Provable truth, the court said, is just too great an onus to put on people who are criticizing government or other powerful individuals, because the threat of suit will have a chilling effect on them. They'll be afraid of these damages and they'll self-censor rather than get out this very important gist that would be really valuable to democracy and really helpful as a check on government. Now, after Sullivan, a set of cases extended this actual malice rule to other people who sue for libel, people who are either broadly powerful or are powerful players within a particular public debate on which they claim to have been libeled. So it applies to all government employees who have or appear to the public to have some substantial control over some aspect of governmental affairs out of which a libel arises. And it also applies to so-called public figures, prominent people in non-government spaces, including those who have sort of achieved widespread fame, the sort of Kanye Wests of the world, and those who have prominently inserted themselves as a key player in some smaller, more discrete public conversation, people who are public figures within a small local dialogue. The theory is that public figures, like public officials, usually enjoy both greater access to the channels of response. They can correct a falsehood with truth rather than wielding this sensorial tool of litigation, and that public figures, like public officials, sometimes have thrust themselves into the limelight and made at least some decision to voluntarily expose themselves to the risks that come with that, including the risk of injury from a defamatory falsehood that happens within that space in which they're a key player. Now, these principles were complex at the time that they were announced, but they're exponentially more complicated in an era with much more complicated modes of counterspeech and much more complicated ways of coming to prominence, and all of the factors that Joey just described for us. And in June, Justice Neil Gorsuch, along with Justice Clarence Thomas, argued that their colleagues on the Supreme Court should have taken a case that would have provided the court with the chance to reconsider and potentially pare back this protection for speech on matters of public concern. And a primary thrust of Justice Gorsuch's argument was that the changed media landscape has left us with a crisis of social media disinformation. Now, I agree that the problem of online disinformation is sweeping and that its impact on democracy is potentially dire. And I hope we'll get the chance to play out some of those questions in our conversation today. It's hard to imagine, though, that adjustment to our constitutional free speech standards in defamation law is going to be the most efficient or effective tool for tackling this monstrous problem. These online mobs of disinformation, disseminating lies that Justice Gorsuch points to are not really natural targets for defamation suits because they're often anonymous and they lack assets for paying damages in these kinds of suits. I don't know of any disinformation scholars who think that the very best, most efficient way to address the disinformation crisis is through these time-consuming, expensive, complicated libel litigations. The entities that are attractive, though, in these suits are news organizations who have assets and who have libel insurance policies and deeper pockets, and so are much more of a target for the kind of legal intimidation situation that Sullivan warns about and recognizes is so harmful to discussion within a democracy. And so while I share Justice Gorsuch's concern about disinformation in a social media age, and think we absolutely need to throw our full weight behind the effort to tackle it, both within law and within the realms of media and journalism and tech, I fear that abandoning the Sullivan line of protections won't actually do this hard work. And in fact, will probably compound rather than alleviate some of these grave problems. Scaling back the Sullivan Doctrine impairs those valuable speakers that are actually still out there actively prioritizing trustworthy news gathering, with maybe no real payoff in solving the online disinformation problem that seems to be driving this reconsideration. Now, on top of this, and in closing, I just want to say that unwinding Sullivan in any way, I fear feeds a really dangerous narrative that has been fostered about the press as an enemy of the people. And because this doctrinal change, this getting rid of the protection that Sullivan provides for journalists, was made very much the centerpiece of a lot of the vilification that the press faced in recent years, a Supreme Court scale back in this space might well embolden those who are sort of already on that troubling trajectory. And I think we've learned a lot of powerful lessons about democracy and its fragility in recent years, and the suggestion that it should be easier in America for those at the center of the nation's conversations on matters of public concern to punish speech about them or to scare critics into silence, I think should make us quite uneasy. But this is a space for vibrant debate, both as to the problems and as to the solutions. And I'm excited to hear from my fellow panelists and especially from all of you. So thanks so much for joining us tonight for that dialogue.
Thank you so much, Professor, for your perspectives. Professor Logan, would you like to share your thoughts next?
Yeah, first of all, I'd like to thank Ohio State and Ohio State Law School for teeing this up. It's obviously very important and interesting, not just academics, aspect of trying to figure out how to make our democracy better in a really challenging time. And my particular approach to this is not to scrap this entire line of cases. And I've tried to make it clear in my writing, in my speaking, that I'm not talking about reversing New York Times, but I am saying we have a living Constitution. We have a very different factual environment than we did in the 60s and 70s when all these cases were decided, and they really haven't been revisited really in 30 to 35 years. It's a different world. And changed facts on the ground are something that people who are committed to having the Constitution find the right balance between various important interests ought to take seriously. So I have 2 or 3 specific reactions to Professor Jones's observations, which were wonderful and spot on. One is because a reconsideration of libel law won't solve the entire problem, is not a justification for not looking to any tool we can find to get a handle on this problem. I think almost anybody that is paying attention recognizes that misinformation, particularly on the internet, has been made far worse by decisions by Congress in the 1990s to take away any responsibility of the platforms from monitoring what goes on their sites. So I would be delighted to have Congress take seriously modifying the CDA, which is the statutory immunity that's provided to internet platforms. And maybe Congress can do that. They can't seem to pass bills to build highways, so I'm not optimistic that Congress is going to anytime soon really get their arms around meaningful reform of the internet. But let's assume for a second that that's a different problem. It's not one that was created by the Supreme Court. It was created by a confluence of technology and other forces that the Supreme Court has very little control over. But the Supreme Court does have control over the constitutional interpretations that started with New York Times v. Sullivan. The second point is, I've said, and I think it's pretty clear, the strongest case you could come up with for inserting the Constitution into libel law was in fact the facts of New York Times v. Sullivan. The decision was unanimous, and virtually nobody in the next 20 to 30 years raised any serious concerns with the balance that was hit by the court in that case involving an important public official who had substantial responsibility over the implementation of important policy, including the behavior of police. In the 10 years that followed, though, it was extended to substantially different situations that did not have the core First Amendment concern about criticizing powerful public officials to all sorts of people who were deemed, for one reason or another, to be not deserving of the protection of libel law that had been provided to them for hundreds of years in England and then the United States. And so, for example, in the modern world, a cop, a firefighter, a school teacher, the victim of Bill Cosby's misconduct, they all are considered public figures or public officials, and they have to scale this extremely high set of barriers that the Supreme Court has established in these other cases that involve people who are enormously far away from in the center of our concern about discussing the issues of the day. So the first point is, I have no qualms with the core decision of New York Times v. Sullivan to recognize substantial protections for high public officials from libel actions. But I think it goes without saying that this has been extended way beyond the contours that animated the Supreme Court in the first instance and leads to some really unfair outcomes. I'll just give you one very simple one. The parents of kids that were killed in Sandy Hook Elementary School, they were deemed public figures because they talked about gun control. And Alex Jones went after them and made all sorts of allegations about them and the fact that their kids were not dead. It was a lie that these parents were putting forward. They defended themselves, they became public figures, and so when they sue Alex Jones, they could prove Alex Jones had actual malice, a very high standard, and lots of other things that the common law would not have made them to do. And in fact, to prove the falsity, they submitted to the judge and the jury the embossed seals on the death certificates of their children to prove the facts that was the basis for their allegations. That's not the right outcome. Yet the courts feel compelled to come down on the side of the media whenever there is any kind of assertion that the person has some kind of public affiliation. And then finally, we have the statistical information. There were 3 libel trials in the entire country in 2018. How many medical malpractice trials were there? How many slip and fall trials were there? How many products liability trials were there? There were many, 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 and yet there were millions of statements, false statements going out in that time. People don't sue because they can't win, and they can't win because New York Times effectively means you will lose, if not a trial, on appeal. So my argument is, and I've got a lot more to sort of respond to particulars, is let's try and recalibrate this balance between reputation and the First Amendment, and with an understanding that the only variables are not the freedom of the press and also the right to an unblemished reputation, but also the recognition that allowing people to lie without consequences insufficiently provides deterrence that we need to have a meaningful democratic conversation about the important issues that separate us. Thanks.
Thank you, Professor, for your insight. Dean Baines, would you like to go next?
Sure, thank you. Can you pull up my slides? So thank you for having me be here. Next slide, I'm going to do a little pivot and then go back to New York Times versus Sullivan. So yeah, I think our democracy is in peril. I mean, I think everything that Dean Emeritus Logan said and Professor Anderson Jones said, or there's a lot of merit in everything they've said. But as Joey indicated in his introduction, what is fact? What is fiction? How do we know? And that's so important for our democracy, because how are you going to vote? You're going to determine who your elected officials are if you don't know what policies you're going to support, if you don't know what fact or fiction is. And how do we know the difference? Well, traditionally, we've relied on the media to help us know the difference, that we believe that the media was true. And part of the challenge is, I think, in the United States, we have a truthiness problem, right? It's a truthiness problem that's existed for quite some time, that we have lost faith in our government leaders from probably the time of the Vietnam War through Watergate, through Afghanistan and Iraq. So you put this all together and then you deregulate the media that we had, which caused even more of a problem. Next slide. So you'll see that there's been a great deal of media consolidation over the past 30, 40 years. And that has led to significant outcomes. It means that media is more consolidated. It has much more power. It is controlling a lot of different media, which means that you may have less availability of different media sources. So there's really only 5 major media companies in the United States. Next slide. And you see them here. I mean, this is this slide's from Wall Street Journal. It's from about 5 or 6 years ago. CBS and Viacom are now combined, and AT&T and Time Warner are also combined. But they control a lot of different media outlets, some of the cable stations, the broadcast stations, other media properties, et cetera. Next slide. There's also a lot of what's called media deserts in the United States, right? So you see the slide, and this is just newspapers. You see the pinkish coral colors where there's no newspapers, the yellow where there's only 1 newspaper, and the light green is when there's 2 to 5. And you can see the majority of the United States has very few newspapers. And what does this mean? It means that there's one, potentially no voice, or 1 voice, right? And sometimes those newspapers are controlled by conglomerates. Sometimes we don't even have local news because the news is produced by somewhere else. And it's all canned and whatnot. And you see this with broadcast stations, radio stations as well. And so it's not surprising that people in some areas may have particular views because they're only hearing one side. And sometimes some of the talk radio hosts or opinions, sometimes that's the only news outlet that people have in terms of radio in their community. Next slide. This shows you sort of the newspaper ownership, which has also been consolidated. So there's much fewer owners. Only 24 companies own nearly 1/3 of all newspapers in the United States. Again, allowing for this consolidation and the divorce of voice of different voices throughout. So when our founding parents created the First Amendment, they thought there were going to be a lot of pamphleteers that there would be a lot of different people all over. They did not envision this landscape with 300 million people and so few media organizations that are so large and so powerful. Next slide. This is a television ownership. So you have 30 owners that own 1,000 full-powered television stations, and you can see them. So again, it's the same sort of thing, that the type of content may be very similar. A lot of places is not an opportunity for people to have local content or independent content. Next slide. Same thing with radio ownership. Major consolidation of radio ownership across the country. Again, allowing for a lot of people in a lot of areas not having the type of news or entertainment that they need to have or want to have. Next slide. And again, we talked a little bit about the sort of social media networks. Again, some of them are very large, very powerful in terms of input. And a lot of people actually consume their other media, their traditional media, whether it's newspaper, radio, and or TV through the internet. So there's this other consolidation. And most people actually look at the sources. Data analysis indicates that a lot of people actually now get their sources of their major media through the internet and through social media. Now, the challenge, of course, is Dean Emeritus Logan indicated that the social media companies are pretty much unregulated. There's been a lot of funny business going on with respect to some of the information that is distributed on those networks. In fact, there was a study just recently that showed that those stories that were false actually had more potency on social media than those that were actually true, because it confirmed people in their little isolated in their little bubbles. And social media is a good thing. All this is a good thing because it does bring people together in ways that didn't happen before. So if I'm an African-American in Omaha, Nebraska, and I want to meet other African-Americans in the state of Nebraska or elsewhere, it allows me to transcend that my particular location, my geographical location, and meet people outside. So it's great in so many ways for people, whatever their issues are, whatever their commonalities are. But on the other hand, it then puts us in these silos where we may not be engaged with other conversations. Next slide. And so how did we get here? A lot of it's been the media deregulation since the 1980s till now. So the Fairness Doctrine was a doctrine the FCC had that required the media companies, the broadcast radio stations, to present issues of importance and to present issues on both sides. So there were problems with it, of course. Part of the challenge, it went sort of the middle. It didn't have like other kind of fringe or other kind of views, but it did provide some basis of correction that if a media company, a broadcast company, a radio company did not produce, it did not present both sides of an issue, somebody could come in and do the same thing. Could do it, can present that. We're given an opportunity to respond. The personal attack rules were related to the Fairness Doctrine. It required individual who may have been attacked or a group that had been attacked to give an opportunity to respond. And all these were eliminated in the late 1980s. Well, the personal attack rule was like 2000. As I mentioned before, there's been easing of newspaper broadcast ownership, cross ownership. So you have some media markets with newspapers and broadcasters are owned by the same individual, same company. There's been easing of media ownership caps in different markets, leading to consolidation. The media companies, the broadcast companies, radio companies had to adhere to the public interest, which was a very detailed analysis of what they were doing for the public. And that was changed also in the 80s and 90s, that they could do that by market forces, which then caused, when you put all this together, and the last few things is that the FCC licenses are auctioned to the highest bidder, as opposed to provided through this comparative hearing process, who might be the best individual to actually operate in the public interest. And you put all those together, and it means that the media companies are getting bigger. They are focusing on the market share and focusing on profitability. And you didn't have 24-hour news stations 7 days a week. So all of that comes together where it is mostly a profit motive as opposed to basically public interest. And as was indicated by others, that there's virtually no regulation of internet or social media. And I talked about the public focus on a public interest has been removed. So what you see, next slide, is a real partisan gap and lack of trust in national local news organizations and social media. And you can see a lot of it happened in the last 5 years. You can assume why that may have happened in the last 5 years. I won't say necessarily why it might. You have to come to your own conclusions in the last 5 years, but you see certainly national news organizations. There's been a definite partisan drop by Republicans and those who lean Republicans. Local news organizations a little bit less, and social media also less. And so you put all those together, and it puts us in a real difficult situation, because how are we going to vote if we can't decide whether COVID is a hoax or whether COVID is a unique public health emergency? If we can't decide whether we're going to take a vaccination or we're going to take some sort of horse worm medication, if we can't decide these kinds of things, where are we going is the question, right? And that's the challenge, I think, to our democracy, is that we need to make sure that we find a way for us to figure out what the facts are, that all members of the public to get the facts. Last thing, as I was thinking about what my other panelists were saying, I want to just mention a few things about race, which I wasn't going to necessarily talk about, but it is one of my areas of expertise. So a couple of things. One is it's important to recognize, I think for the civil rights movement, I think a lot of students, younger students, think, oh, it all was kumbaya, that Martin Luther King gave a speech and everything was okay. No, it was not that way. There was a lot of violence toward the civil rights workers and leaders. It's really important to remember that. And the media played a role or didn't play a role. And so that's why New York Times versus Sullivan is so important, because the media in the South failed to cover the civil rights movement. They failed to cover it. And there were actually litigation against some of the broadcast properties. I'm thinking of United Church of Christ, which was in Mississippi, that failed to cover the civil rights movement. It went all the way up to the DC Circuit case, because under the Fairness Doctrine, they were not providing information on an important issue, and we're not providing both sides of an issue. So it's important to recognize how race played a real important role in this. Also, it's important to recognize that the Kerner Commission, which studied the civil rights problems situation and the civil unrest of the 1960s, cited the media as part of the problem, that it didn't cover both sides of the issue, didn't cover the issue at all. African Americans were basically almost non-existent in the media generally. So putting New York Times versus Sullivan in that context is important for us to recognize how revolutionary and how important that decision is. Because if in fact that libel case was going to stand, there would be no coverage in the rest of the United States about those issues. And that's really important. And last point on race and how race impacts this, what I think is very important, is that I appreciate what all of you are saying, that there may need to be some re-looking, a re-evaluation of New York Times versus Sullivan. But let's be clear, there are certainly those individuals who are high-ranking officials, whether it's members of Congress or whether it's the president or vice president, people with a big voice, who this is where I think a lot of this revisiting is aimed at, and they have big voices. Many of them have very big Twitter followers, media covers them. There's not going to be a problem if in fact someone says something false about them. I don't think it's going to be a big problem for them. The problem is for those individuals who are recording police violence. So think about them, right? They are on the street acting as a reporter themselves almost, or a photographer. They may not have any credentials at all. And they're videotaping, and their videotaping has made a big, big difference in Americans' perception about racism with respect to police brutality. A big difference. People didn't believe it, and some people still may not believe it, but they didn't believe it until they saw it on videotape, right? They didn't believe it until they saw it on videotape. Imagine what happens to those individuals who are basically acting like a journalist and not journalist, acting like a reporter. They may be thrust into this, and the police are thrust in this thing. And if you reduced and lowered the standard for New York Times versus Sullivan, it will chill those individuals who will be out there trying to make sure that people see what may be going on. And so I do think that's all concerned. I know I probably spoke more than I needed to, but I just, I wasn't going to talk about race, but you know me, whenever you talk about this, I have to talk about race. So, but thank you for this opportunity to talk to you all about this. I'm talking like a Texan y'all. And so many, many thanks. And I look forward to other questions. Thanks on these issues.
Thank you, Dean, and to our panelists for setting the stage. Wow, 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 wow. Your ability to make these issues accessible and pertinent is genuinely impressive. I am floored. Next, we'll transition to a Q&A to wrestle with those larger socio-political questions for both the audience and the moderators. Carly, take it away.
Thank you, Joey, for doing a wonderful job of leading us through the first half of this panel. And thank you to our panelists for a great thought-provoking discussion so far. Now we are going to move to the question and answer portion of our event. Paul and I have gathered some questions that we generated, as well as some that were submitted from the audience, and we will take turns asking those questions of our panelists. I will direct the questions to a specific panelist, but the others are welcome to chime in if they have more to add afterwards. My first question is about an issue that I think is really timely and exciting in this area, so I'm interested to see what you all have to say about it. And I'm going to direct it towards Professor Jones. So my question is, how does this case relate to the spread of fake news and disinformation online, especially on social media platforms?
Yeah, I think this is maybe the critical question of the moment. And the reason it is both, you see it as an undercurrent in the sort of motivation that we see in Justice Gorsuch's dissent from denial of certiorari in the case earlier this year. And we see it at the sort of in the centerpiece of some of the biggest Sullivan invoking cases that are on deck right now. So there are a number of cases that emerge out of what some have labeled the big lie, the perpetuation of false information related to the election of 2020. There are a couple of very big, very prominent libel cases that are being brought, for example, against Fox News. There was one filed against a number of, naming a number of Fox News hosts, in addition to Fox News, the entity itself. These cases were brought by the companies that run the voting machines. So companies whose names were mentioned on air in relation to some of these stories that they, right, if you read the filings in these cases, they're invoking the same kinds of language that you're invoking, right? Fake news, the distribution of this, and they are invoking the phenomenon that you're describing, which is this may have initially happened on a Fox News broadcast, but was disseminated widely through some of these mechanisms that both of my co-panelists have just described, spreading and becoming more viral more quickly through sort of insular groups of people online who are spreading information through social media and otherwise. And those concerns are at the heart of what we're thinking about in some of these debates. The question of fake news has become a really, really divisive one. And in part, I think, Carly, the reason that it's become divisive is that it's a label that has been attached to two very different phenomenon. So on the one hand, those of us who work in the media law and First Amendment space have sort of heard this term and referred to this term in sort of its literal sense. News, something that purports to be information on a matter of public concern, but is fake, right? It has been falsified. It's been generated, cooked up from scratch, distorted, or made up. But there is also an increasing tendency in a political space to refer to things that people just don't like, right? Or to media that they think is biased against them, or that has a slant, or that is news that they wish hadn't been broadcast as fake news. And I think that the labeling question also complicates things in this space. There's a scholar named Lily Levy at the University of Miami who wrote a really interesting piece called Real Fake News and Fake Fake News that tried to kind of tussle through these dynamics. And I think, Carly, you've hit the nail on the head in terms of the kinds of inquiries that we have to make in this space. Figuring out how to stop that first thing, right? Figuring out what kinds of legal and regulatory and tech and media solutions we can find for halting or at least slowing the dissemination of disinformation and misinformation on the one hand, while not bleeding into a space in which this label, this fake news label, precludes us from having critical analysis on matters of public concern.
All right, Professor Logan, I have a few questions for you. I know, Professor Jones, you discussed it's important to make sure that critics of public officials aren't necessarily silenced. It's important to have that discourse in the public field. Professor Logan, you mentioned a few times in your introduction, striking this proper balance. That's something I'm interested in. I know a lot of people are interested in terms of, to you, what would history maybe suggest, or what is that proper balance? What are some steps that Congress or the courts could take that you think would be more formidable than what Sullivan currently stands?
Well, let's put aside steps that Congress could take. There's a lot of things Congress could do within the contours of the First Amendment to deal with some of this disinformation problem on the internet. I'm just addressing myself to constitutional law doctrine, and that's, of course, the Supreme Court of the United States. You know, they made this up out of whole cloth. There's no place in the world then or now, by the way, that has the same array of protections for liars and people who misstate the law, misstate facts that we do in the United States. We are way beyond England, Australia, any other country in the world in terms of shielding people who purvey falsehoods. So I'm addressing myself to what we can do within our constitutional system. And there were, depending on how you count, 7 to 10 ways in which New York Times v. Sullivan changed the law that had been in place for hundreds of years from England and the United States. Some of them relatively innocuous on the face, but very, very important in practice. For example, the burden of proof on the question of falsity. It may seem like, well, that's like not a big issue, just prove that the fact is not a fact. As the dean said, that's not easily done. So moving the burden of proof to the plaintiff was a significant change. And there were, as Professor Jones said, the establishment of independent of that, a very, very high standard of proof that basically says you've got to prove that person is consciously lying in order to recover damages if you fall into these categories of public figure or public official. A third and important part of this is that one of the issues that underlies this, and Professor Jones is absolutely right, and I don't have the number in front of me, but $500,000 in Alabama in 1961 or 62 is millions of dollars in Alabama in 2021. So this was a huge award. And as the professor said, there was almost no evidence of any actual harm to Commissioner Sullivan from these false statements. They were relatively minor, although there were some that alleged the police bombed Martin Luther King's home, and you could make the argument that Commissioner Sullivan was tarred by that brush. But putting that aside, and I agree generally, the thrust of the advertorial was accurate and important. But to require the plaintiffs in all cases after that don't involve criticizing powerful people in the sense of people who have the levers of government in their hands, that's been extended to many, many, many other situations far removed from what we would call the model of seditious libel. As Justice Brennan said, what Alabama is doing here is punishing criticism of the state. And that was a big part of why the First Amendment, although not the only part, was adopted in the first place. Because in England, seditious libel was something that was not particularly regulated. And they didn't want this to be the rule of the road in the United States. So I would be delighted to see a much narrower definition of who is a public official, to not include the cop and the teacher and the superintendent of the rec center. I would love for there to be a much narrower definition of who is a public figure, so that, for example, LeBron James or Kanye West, loses his ability to protect his reputation just because he's really famous. That's not fair to people like LeBron James and Kanye West, even if they can rebut in ways that maybe you and I can't. And third, and this is more sort of inside baseball, but there was a time within the Supreme Court where a number of justices said this actual malice standard that Professor Jones described is too high, even for public officials. Lower it down to something that's more like gross negligence. And that's sort of inside baseball for torts teachers, but it makes a big difference in your ability to get to the jury and on the ground in actual cases. And so I would argue that some combination of these tweaks over a period of time with lots of opportunities for thorough briefing from the parties, and I can assure you these cases get a lot of attention from the very powerful people that Dean Baines described. This will not go unnoticed. This will not slip under the radar. And through this conversation over the next 5 to 10 years, come to a more fair balance between the interest in reputation and the interest in being free to publish whatever you want. And again, part of my emphasis is democracy is in the balance here. And that when you do not have restraints online that come from tort law, we can't figure out, as Dean Baines said, what's true and what's false. And democracy suffers as a consequence. And I'll just read you a quick quote that comes from Hannah Arendt, who was a philosopher, political philosopher at the turn of the century. I've got it somewhere here, but I can't find it. But basically she says, you know, the Nazis and the communists, they don't have to convince people of how right they are in a democracy. They just have to convince people that there isn't a democracy, that they win when people don't trust that the government is more or less turning square corners. And what people say about the government and the government officials does make a difference. Thanks, Paul. I hope that answered your question.
Thank you, Professor Logan, for sharing your thoughts on that. I now want to turn to Dean Baines to ask kind of a two-part question. So this also comes from an audience member. So it's a combination of something I was thinking about in preparing for this and something that an audience member was also wondering about. And that is, what is our role as citizens in holding the press, an arguable pillar of our democracy, accountable? And then how can we reestablish confidence in the media?
You know, those are really hard questions. So I had answers to them. But let me start out by first addressing sort of what Professor Anderson-Jones and Professor Logan said, and then get to that. And I think that, you know, Professor Logan really hit the, Dean Emeritus Logan really hit the nail on the head. And part of it is that our society and our First Amendment, our conception of the First Amendment has always been that more speech is better, that we allow people to say almost whatever they want, and there's two sides of a coin, and that people, the population, can then decide what is true and what's right. That's the marketplace of ideas. We have all these ideas, some of them may be true, some of them may be not, and then people decide. And you see it over and over, right? Embedded in our law. You know, not just what we're talking about with Sullivan, to New York Times versus Sullivan, but we see it with respect to, you know, what the media, you know, so people say the other side is up, right? The reason why they don't like the traditional media is because they always want to find the other side, even if there's really no other side, right? Does the president lie or did the president not lie? No, we're not going to say that. We're just going to say, well, we're going to come up with some other issue to sort of describe what might be going on. It comes up with the TV commercials for political campaigns. What we have is that they will say it's produced by, you know, Senator, you know, so it's such and such, that this is his statement or her statement, but there's no one's monitoring what is said. And many times what's said is at minimum misleading and many times false, right? You see it even at the FCC with a lot of its rules. It's just all about getting as much information out there and the public decides. But as I said before, and this is in the beginning, our founding parents did not expect for us to live in this world with all these different channels, all these media sources, that people have, you know, full lives with 2 working family members, and people not having, sometimes have working 2 jobs, they didn't envision that people are going to have the time to look at all this data and sort of see, right, and make a decision themselves. That's the challenge. So your questions were, what roles do citizens have? Well, I think it's important for for citizens all to know exactly what's going on, right? To know that there is media consolidation. There are movements that are opposing the media consolidation that people can get involved in. There's media reform movements. There's media, there's all these different movements that there have been movements about, regulating and re-regulating the media companies, to regulate the internet companies in a way. So I think average citizens should get involved in that. And I think it's going to be a long battle, because when someone charges that there's fake news, or that, as Professor Anderson-Jones says, if we're calling stuff fake news, if we're saying elections are not fair, I think it's hard to get back. That's why I say our democracy, I think, is in peril, because I think it's hard to get back from that. I just think it's very, very hard. Not impossible, but I think it's very, very hard, because once you lose trust, it's hard to get trust back. And it's hard to get trust back if I fundamentally may not agree with the political opinions, right? I may have this suspiciousness already about whatever media sources, and it's hard to get back. I don't want to be a downer, but I really think what I would encourage our students and listeners and viewers to do is really get involved, right, as much as you possibly can. This is our democracy. As a republic, we need people who are informed, who are involved in the civic discourse, who are involved in politics. All of you can make a change, and that's really the difference. That's the only way we're going to move forward with this, and hopefully we do, because I do think that we are in really difficult situation, and I don't think we are. I think sometimes, in fact, I think the media is sugarcoating it to some extent. I think that I think some politicians are sugarcoating it. I think the media is sugarcoating it, because I think people don't want to believe that we are in that we're in as much peril as we have been with respect to our democracy. It's hard to believe. It's not what we've been taught in school. But we've got to get involved to make sure that whatever your political affiliation is, that all of us of good, intent, want the process to be fair. We want the process to work well. We want to make sure there's always, a free transfer and legitimate transfer of power. We've never had this situation where people are saying, oh, this was, the election was illegitimate even before the election was, decided. I mean, you saw this even in California recently. And so I just think that those are all really warning signs about our nation that we all need to take heed of if we want to keep our democracy. I mean, I hate to be doom and gloom, but I just think that what we've seen over the past few years is just it's a difficult situation, as I want to put it. It's a very difficult situation right now. I see
Professor Logan
has his hand up.
I just want to tie together something the dean said before to a thought I have about this, which is it turns out that these news deserts, these large swaths of the country that used to have local news coverage are not able to do it, even with a weekly publication. And there is strong social science data that says that an absence of local news coverage diminishes the public's willingness to get involved in politics in the first instance. And secondly, means that there's no checking function on the behavior of local governments. So for those of us that are concerned with police misbehavior, it's not just in LA or New York or Boston or Houston. It's in little places and in places where it's not just police misbehavior, but misuse of government funds. If we don't have local media covering it, people aren't going to be governed well. And if people don't feel they're getting the information, they withdraw from the field of public engagement. And I think a lot of people now are saying, a pox on both your houses. I can't figure out what the truth is, so I'm just not going to commit myself to the hard work that you've identified of trying to sort through all this information. And I think that is an enormous problem. I think you hit the nail on the head on one part of this. But again, I don't think that constitutional law has played much of a role in that. The forces you're identifying are very large capitalistic forces, deregulatory instincts under both Democrats and Republicans in the 80s and 90s and aughts. And there are definitely legislative changes that could help that. But my narrow little focus is sort of, you know, the Supreme Court broke it. Maybe the Supreme Court should go ahead and fix it, but it's not going to solve the whole problem by any stretch of the imagination. Thanks.
So moving to another question, it's actually a question that came from the audience, and something I was wondering as well is just in terms of context. I think context is important. We've already mentioned a few other countries. So when we're looking kind of at our First Amendment rights in the actual malice standard currently in place, how are we doing comparative-wise, truth-wise, compared to other countries? Do these countries that don't require actual malice have more reliable media environments? Are we hearing as much about these anti-vaccination claims, things like that? Professor Jones, if you want to comment.
Yeah, I think that this comparative dynamic is a really interesting one, and especially interesting one when talking about the Sullivan Doctrine, because we do stand alone in the world in sort of American style free speech and free press demands within the defamation and libel space, and it is something that we have traditionally described, that the Sullivan Court described as a uniquely American value, housed in a First Amendment, which is itself unique. The US Constitution's provision for freedom of speech and freedom of the press as an elevated fundamental right is unique amongst world democracies, and is often the thing to which we point when we describe, you know, sort of how we ended up with a Sullivan actual malice standard and other countries didn't. It's worth noting, sort of a decade and a half ago, there was a sort of a wave, a phenomenon that some people referred to as libel tourism, right? The notion that if you were a person who wanted to bring a libel suit, you were a prominent person who wanted to bring a libel suit, you would hunt around for whatever country in the world is sort of large-scale jurisdiction shopping, hunt around for other jurisdictions in the world that had lesser standards, that put the thumb more on the scale for reputation than for free speech. You'd bring your suit in England if a copy of the book was sold at the airport there, and then try to enforce that judgment here. And the United States Congress unanimously passed a statute called the Speech Act that said, we don't recognize those judgments. Libel judgments that were brought in places that don't have our First Amendment actual malice standard can't be enforceable here because it's a value that is so central to our democratic scheme and to our First Amendment values. The wider question of what impact this has on truth and falsity and the flow of information on matters of public concern is a hotly debated one. Your questioner is sort of tapping into a number of things that are being explored by both legal scholars and empiricists and social scientists to try to sort of get to the bottom of whether sort of which system works better, which system produces the outcomes that you want in a democracy. And one of the things that's tricky about it is that there are competing outcomes of what you want in a democracy, right? You want people not to feel stifled by government and the powerful. You want truth to flow. You want the press to behave responsibly, right? Those are all value systems that are at play here. There's a great deal of data that suggests that in comparison to, for example, the English system, that the press, the sort of mainstream legacy media in England behaves significantly less responsibly than the press in the United States. That is, that they engage in a great deal more libelous behavior, knowing falsity, distribution of knowing falsity amongst the sort of tabloid press in the UK than happens in the US under the Sullivan standard. Lots of different scholars have tried to sort of get to the bottom of various explanations for that. and some of them are cultural, and some of them are regulatory, and some of them are legal, and some of them might be constitutional. I think we can expect, and I know that there are studies happening at the moment to try to answer the questioner's more precise question. So for example, misinformation and disinformation on election fronts and on public health fronts are being studied in great detail right now. And some of the results of those studies, I think, might be persuasive to those who are, might be useful to those who are thinking about whether a reworking of Sullivan would make a difference as a practical matter.
So I'd like to, I can't talk about the New York Times versus Sullivan, but I can talk about two other areas that Europe is different. One is certainly racial hate speech on the media. And so, you know, they reckon, most of Europe reckoned with World War II and Nazism. And so a lot of that is banned on the media. So, that's one thing that they reconciled their past. Now, it doesn't mean it's that racism or anti-Semitism doesn't exist, but they recognize that in public airwaves, you shouldn't have it. The second thing is that with elections, in France, especially, I'm not sure about the other countries, they'll actually have like a 2-week window before an election where you can't broadcast the media can't talk about the election, right? They can't talk about the issues, they can't talk about anything. There's like a 2-week period of time, like a media-free zone with spectators. Again, it's a way for people for us old enough to remember when there were 3 networks that only had like an hour a day, or 2 hours a day, or whatever it was they had, you know, people had to rely on themselves to deduce and to figure out what the meaning of the information they were receiving. They had to talk to their friends and family and themselves, as opposed to having somebody on, you know, opinion stations say, well, this is what this means, or this is what that means. They had to figure it out themselves. And sort of that, I think it's an interesting way to deal with it. And also, I think, you know, they also have, free broadcast time for people running for office. That's another way. Again, it's a way to remove big money from it, to provide people access to information. So I think there's a lot of things that they do differently that I think could be done very well here that may make our elections a little bit more truthy than they currently are.
That's great. Thank you, Dean Baines. Professor Logan, would you possibly be able to outline what the practical effect would be on the media if New York Times was overturned or reconsidered, as you suggest? And do you think that this would help limit disinformation online? Or maybe, as discussed earlier, it wouldn't be very effective because some of the people spreading that information aren't great targets for libel suits?
That's one good point. And a second point, just to bolster that, is a lot of misinformation isn't libelous. Saying that the vaccine makes you magnetic isn't a libelous statement. It may be ridiculous and false, but it's not a libelous statement. So a pretty significant chunk of misinformation on the internet is not attacking a particular person. It's just polluting the overall environment in which individual people are operating. So it lowers trust and the like. I think that I'm not sure that some of the suggestions that Dean Baines made would be constitutional. I could imagine a pretty big objection to a media freeze out for 2 weeks before the election. But I do think that there are ways in which we can take some of the pressure off to publish without checking. I wrote an article about 20 years ago. It's called All Monica All the Time. And I raised the impact then of the 24-hour news cycle on reporting. And the reality is now, the New York Times doesn't publish once a day. New York Times publishes 24 hours a day. And they're constantly updating. And they're constantly needing to match the scoop that maybe comes up on the Drudge Report or comes up on some other platform that doesn't have the same scruples, as Professor Jones says, that the New York Times might have. But they are pressured to get that out fast because it's all about clicks and eyeballs. And if they run slow and a fast breaking story, they keep waiting to verify it, they lose that race, and that race is all about money. And of course, as you may know, the New York Times, for those of you that are subscribers to any print publication, it's about 25% of the bulk that it used to be. They're driving people to go online because there's no incremental cost to having me be a viewer of the New York Times online, where there is to print this piece of paper, ship it, and have it delivered. So they have a big interest in ramping up their internet presence. And the internet presence has this pressure to publish very quickly. So one small thing is, and this doesn't come up very often, is when the media is sued, they can defend by sort of saying it's a dog eat dog world, and I had to publish as a competitive response to my coworkers, and that's reasonable for me to do that. That's not going to be really relevant in an actual malice case. But anything we can do to slow down this freight train of misinformation and to give reporters and editors a chance to actually fact check rather than publish and then fact check, I think will be to the benefit. We don't need to know tomorrow at 6 a.m. Every piece of news that might be out there. How about 8 a.m. or how about noon? And have some fact checking and some exercise of editorial judgment that comes with that. The internet doesn't facilitate that. It undercuts that.
All right. I have another question that I think is important to walk away from this conversation with. And it's generally if each of you want to maybe give your perspective or opinion on, and it's really, we've talked a lot about maybe what the court should do or options they have, or even what the Congress should do. But what do you think will actually happen? Where do you see this going in 5 years, 10 years, even 25 years down the line? If Professor Jones, you want to go ahead and start with that.
Yeah. This is the $1 million question, right? The where to lay our Vegas odds about what the court will do. A lot of the scholarly work that I've been engaged in recent years has, with my co-author Sonia West at the University of Georgia, has focused on broader trends in the characterization of the press by the United States Supreme Court. Those trends indicate that the court overall, both on the left and on the right, has become less positive about the press and less inclined to embrace legal doctrines that are protective of the press and the press function. So as a sort of 33,000 foot level inquiry about whether the tone of protectiveness on freedom of the press at the court is high, I would say it isn't. When we read the tea leaves as to individual justices, I think it's incredibly hard to say. We know that there are two justices, Justice Thomas and Justice Gorsuch, who would have taken the Berisha case that was in front of the court earlier this year. They voted to do so. They expressed in the US reports, they wrote a dissent from denial of certiorari saying that they would have voted to do so. Interestingly, I think it's important to note that Justice Gorsuch, who has taken a sort of, whose approach was sort of, I don't really know all the answers, but I do think that it's worth reconsideration because of these changing circumstances, cast that vote in a case that had a very sort of classic public figure, not one of these sort of tricky public figure cases where somebody became a public figure because of a victimhood or because they were involved in a jet ski website or because they were, ran the rec center for a local town. It was a person who was the son of the prime minister of Albania, who had been repeatedly on the front page of the New York Times and Washington Post, and was sort of the Donald J. Trump of that country, and by his own admission had 100% name recognition in his own country. And so there is at least some indication that at least some justices on the court aren't looking to do something small to Sullivan, but might be willing to do some larger rethinking. There is a lot of chatter circulating about Justice Kagan, where she might be on this as a result of some scholarly work that she wrote a long, long time ago as a legal academic, book reviews of books that were written about Sullivan and the aftermath of Sullivan. And I do think that there is a general tenor at the court of wanting to think about the role of social media. The court has just recently sort of caught up to wanting to think about the role of social media and to address that issue in its broader First Amendment landscape. We see this in a bunch of different cases on other topics. where there's a sort of momentum there. Whether it will actually catch fire and move in that direction, I think remains to be seen. It takes 4 of them to agree to hear the case, and it takes 5 of them to do anything in that case. And so far, we can't count to either 4 or to 5. We can count to 2. But I do think the First Amendment is an area in which we have a long history of powerful dissenting views arcing their way into majority opinions. And so this is a place where it's worth paying attention.
Well, my 2 cents is, I think that whether we go from 2 to 5 will turn largely on the sort of more global sense that this court is less respecting of stare decisis and the power of precedent than courts have been before that. And of course, it's ironic because this would be a living constitution argument made by sort of judicial conservatives, whereas 50 years ago, it was, the shoe was on the other foot. We're changing the Constitution, and the conservatives were saying, "Oh, don't do it. It's rock solid. Don't change the Constitution." So that's one question, and I think, in particular, Justice Alito suggests that he's not particularly wedded to stare decisis as a general matter. And he has filed some pretty angry opinions in the First Amendment context involving, for example, the Westboro Baptist Church case and others, where he is very comfortable with staking out a position that is sort of idiosyncratic and not in the mainstream. Of course, we don't know what the newest justice, what her position is going to be, but I think there's a reasonable chance there will be 4 within a year or 2 with the right case. And some cases are now coming up through the court system that could raise these issues. I do think, though, it's important to understand that the sky is not going to fall if we tweak New York Times v. Sullivan. And I think that there is a real sense of a lot of people who are associated with the media that this is sacrosanct, that if we even consider changing any part of it, the whole house of cards, the democracy and free press, will fall aside. And I just want to suggest that Chicken Little arguments aren't particularly persuasive. Let's look at what's actually happening on the ground. Let's compare it to what's going on, as Professor Jones says, in other jurisdictions, other cultures and other legal systems that don't follow us, and try and see if we can reach a better accommodation so that there is some deterrence for liars. And I think that's going to pull a 5th justice in there, but I certainly don't expect, I don't want us to throw New York Times v. Sullivan out the door. The core idea that we've got to give some constitutional protection for false statements of fact is going to go forward, and I would support that.
All right, and with that, I'm going to thank our panelists for an incredible discussion, so enlightening, and I think a wonderful embodiment of exactly what we're trying to do here at Ohio State, is to have civil discourse on the issues of the day that are so important, not only to our democracy, but to our society and to each other. I also want to take a moment as the College of Law's Dean to thank our student panel, our student moderators, Joey Otang, Carly Sinclair, and Paul Stallman, who did a terrific job. And for some very brief concluding remarks, I'll now turn to my co-chairs of the Education for Citizenship Initiative.
First of all, I want to thank our panelists and I thank our students for participating today. This dialogue was enriching. It gave us something to think about. And certainly the muse popped up for me, and I'm sure it will pop up for others. I hope tonight's discussion also sparks continuing discussions that can take place on and beyond our campuses. I thank each and every one of you for participating, and I encourage our audience to go to our website to learn about future events. And now I'm going to pass the baton to Keisha Mitchell.
Thanks, James. Sorry about my technical difficulties there. Again, I'm Keisha Mitchell, the Associate Vice President for the Office of Institutional Equity. This is the very kind of discussion we hope to inspire in this initiative, and we are living up to the university's motto tonight. I want to offer my appreciation to Rennell Anderson-Jones, Leonard Baines, and David Logan for framing this issue so superbly and providing us with so many insights about the issues involved. We are truly appreciative of you all being with us here this evening. And I, again, thank you all for joining us.